In Canada's parliamentary democracy and constitutional monarchy, Parliament is responsible for making laws. Parliament consists of the House of Commons, elected members, the Senate, appointed members, and the monarch, the King, represented by the Governor-General. To become federal law, a bill, a proposed law, must be approved in the same form by both the House of Commons and the Senate, and then receive royal assent, formal approval, from the Governor-General. This multi-step journey of a bill through debate, review, and voting in Parliament is called the legislative process. In the following sections, we will explain each key step in how a bill becomes a law in Canada, from the initial idea and drafting all the way to royal assent and implementation. From idea to draft bill. Every law starts as an idea or a need for change. Ideas for new laws often come from the public. For example, citizens may raise issues by contacting their members of Parliament, signing petitions, or discussing ideas during elections. A parliamentarian, either an MP in the House of Commons or a senator in the Senate, takes that idea and proposes it as a bill. Bills can be introduced by the government, usually by a cabinet minister, or by individual legislators not in government, often called private members' bills. Before a bill is introduced, it must be written in legal language. This is the drafting stage. If it's a government bill, lawyers at the Department of Justice draft the bill following instructions from Cabinet, the Prime Minister and ministers. For a private member's bill, from an MP who is not in Cabinet, professional legislative counsel in Parliament help draft the text. The result is a draft bill ready to be presented in Parliament. First reading, introduction of the bill. First reading is the initial stage at which a bill is formally introduced in one of the two chambers of Parliament. A bill can start in either the House of Commons or the Senate, but most commonly begins in the House of Commons. At first reading, the bill's title and purpose are read out and the bill is officially placed on the agenda. There is no debate at this stage. In fact, despite the name first reading, the bill is not read aloud in full. Instead, the bill is printed and made available for all members of that chamber and the public to read and examine. First reading is essentially a formality that signifies the bill's introduction to Parliament. After first reading, the bill is typically published so that legislators and citizens can review its content. This transparency allows everyone to understand the proposal early in the process. Once the bill is introduced, it proceeds to the next stage for consideration of its merits. Second reading, debate on principle. Second reading is the stage where the real debate begins. Members of the House or senators, if the bill started in the Senate, debate the bill's principle or main idea, essentially discussing the overall purpose and whether the idea behind the bill is sound. This is a critical stage because it focuses on the broad policy aspects of the proposal. Parliamentarians will highlight the bill's strengths and weaknesses and how the proposed law might affect different groups or the country as a whole. The goal of second reading debate is to allow a full airing of viewpoints. It gives both government and opposition members a chance to voice support, raise concerns, or suggest what issues need closer study. After sufficient debate, the chamber holds a vote on the bill at second reading. This vote decides whether the bill will proceed further. If a majority votes in favor, the bill passes second reading and is sent to a committee for detailed study. If the bill is voted down, defeated, at this stage, it fails and goes no further. A bill can be stopped at any stage if it fails to get majority support. Assuming the bill passes the second reading vote, it moves on to the committee stage for in-depth examination. Committee stage, detailed study. After passing second reading, the bill goes to a committee, a smaller group of parliamentarians, MPs or senators, chosen to study the bill in detail. The committee stage is where the bill undergoes a thorough, clause-by-clause examination. Committee members consider each section of the bill and often hear from witnesses, such as experts, officials, or citizens who have an interest in the legislation. These witnesses provide input, answer questions, and help committee members understand the implications of the bill. Committees have the power to recommend amendments, changes to the bill's wording. Members of the committee debate and vote on any proposed changes. They may amend the bill to fix problems, add clarity, or address concerns raised during testimony. This is a crucial part of the process, as it allows for improvements to the bill based on expert evidence and public feedback. Once the committee has finished reviewing the bill and voting on amendments, it votes on the final version of the bill and prepares a report. The committee then reports the bill back to the full chamber, along with any approved amendments. Report stage, considering committee amendments. After the committee reports the bill back, the next step is the report stage in the chamber where the bill was first introduced. At report stage, the House or Senate reviews the bill again, now considering the committee's report and any changes that were made in committee. Essentially, the chamber gets an update on what the committee did. Members can debate the bill further, focusing specifically on the committee's amendments or recommendations. Importantly, at this stage, additional amendments can be proposed by any member of the chamber, not just the committee members. For example, if some members feel the committee's changes didn't go far enough or went too far, they can move motions to amend the bill further. All proposed report stage amendments are subject to debate and votes by the whole chamber. The Speaker of the House may group related amendments to streamline the debate. Once any report stage amendments have been dealt with, voted on, the bill is finalized for the next step. If no new amendments are proposed, the report stage may be very short, often just a formal vote to accept the committee's report. After report stage is completed, the bill moves to its third reading in that chamber. Third reading, final debate and vote in first chamber. Third reading is the final stage of debate in the chamber where the bill originated. At third reading, parliamentarians debate the bill in its final form, which now includes any amendments adopted during committee and report stages. This is the last chance for the House or Senate, if the bill started there, to discuss the contents of the bill before the final vote. Debate at third reading is typically more limited and focused, since the broad principle was approved at second reading and details were handled at committee. Members might use this time to make final arguments for or against the bill, or to explain their position to the public. After debate, a final vote is taken on whether to pass the bill and send it to the other chamber, or, if it's already passed both chambers, on to royal assent. Members vote yes or no to the bill as it stands. They may have supported it earlier but could still vote against it now if they are unhappy with changes made along the way. If a majority votes against the bill at third reading, the bill is defeated and will not become law. If a majority votes in favor, the bill passes third reading. For a bill in its first chamber, passing third reading means it has cleared all stages in that chamber. The bill will then be sent to the other part of Parliament for further scrutiny. The Senate's role, second chamber review. After a bill passes all three readings in the first chamber, it must go through a similar process in the other chamber of Parliament. In Canada, most bills start in the House of Commons and then go to the Senate, but a bill could also start in the Senate and then go to the Commons. For explanation, let's assume the bill began in the House of Commons. In that case, the approved bill is sent to the Senate. In the Senate, the bill again goes through first reading, second reading, committee, report stage, and third reading just as it did in the House. Senators review the bill's content, debate its merits, and can call their own witnesses in committee. The Senate serves as a chamber of sober second thought, providing a second layer of review and often suggesting improvements or fixes. If the Senate passes the bill without any changes, then the legislative process is almost complete. In this case, the Senate sends a message back to the House informing them that the bill is approved as is, and the bill can move on to receive royal assent. However, the Senate may sometimes make amendments, changes, to the bill during its review. If the Senate amends the bill, it does not become law yet. Instead, it must return to the House of Commons for the Commons to consider those amendments. The House will debate and vote on whether to accept the Senate's changes. The two chambers must ultimately agree on the exact same text of the bill. This could involve the bill going back and forth between the House and Senate via messages, if there is disagreement on amendments. In practice, the House usually accepts many Senate amendments that are technical or non-controversial, and negotiates on others until a final compromise is reached. If the two chambers cannot agree on the bill's text, the bill fails and does not proceed. But if both the Senate and the House of Commons have passed the bill in identical form, the legislative approval is complete. Royal assent, formal approval by the Crown. Once both chambers of Parliament have approved the bill, the final step is royal assent. Canada is a constitutional monarchy, So any law passed by Parliament requires the formal assent of the monarch, king, or queen to become official. In practice, the monarch's representative, the Governor-General, gives this approval. Royal assent is often granted in a ceremony held in the Senate chamber, where the Governor-General or a deputy, such as a Supreme Court justice, nods or signs a document to signify approval. It can also be done through a written declaration delivered to both houses. Once royal assent is given, the bill officially becomes an act of Parliament. In other words, it becomes law. Notably, no Governor-General has ever refused royal assent to a federal bill in Canada, as royal assent is largely a formality in modern times. At the moment of royal assent, the new act is assigned a chapter number and added to the statutes of Canada. This signifies that the legislative process is complete. However, being law on paper does not always mean the act has immediate effect. We must consider how and when the law actually comes into force. Implementation and coming into force. After royal assent, the bill is law, but implementation of that law can vary. By default, a new act comes into force, i.e. has legal effect, on the day it gets royal assent, unless the act itself provides otherwise. Many acts specify in their text when they will come into force. Some laws state that they come into force on a particular date in the future, or on a date to be set by the government. It is common for acts to include a clause saying it will come into force on a day to be fixed by the governor in council, the federal cabinet. This means the government will decide the start date, often by issuing an order in council at a later time. This flexibility allows government departments to prepare for the new law, for example, by training staff or writing necessary regulations, detailed rules that flesh out the law. Regulations themselves follow a separate process after the act is passed, and they enable the enforcement of the law's provisions. In summary, once a bill has passed all stages in the House of Commons and the Senate and received royal assent, it has completed the journey to become a law. The law may take effect immediately or at a later date as specified. From the initial idea and drafting, through readings, committee scrutiny, and approval by both chambers, the legislative process in Canada is designed to ensure that proposed laws are carefully considered and debated at every step. This thorough process helps maintain a democratic, transparent system for turning ideas into the laws that govern the country. Every step, from first reading to implementation, plays a vital role in how a bill becomes a law in Canada, keeping our legislation well considered and effective.